She immediately texted Justin to apologize, terrified that one impulsive comment could damage his legal case. The fact that she was afraid to tell the truth reveals just how powerful the pressure had become. For an entire year, she watched her friend be publicly defamed before finally deciding she could no longer stay silent.
According to the docket, this is here on a show cause that Judge Lockhart Nash issued regarding the defendant's attorney, as well as a motion that he has filed pro se to remove counsel and proceed pro se. And then there's also a motion for contempt. Let's first deal with the issue regarding the show cause and motion to withdraw. Ms. Conger, do we have who is the attorney? I'm not familiar with this case, so I'm trying to. Ms. Hudson is the attorney that was representing Mr. Gang. Is that correct?
I represent Miss Gang.
Okay, you represent Miss Gang, Mrs. Gang.
Yes, Your Honor.
And she is here with your Miss Gang, correct? Then we have a show cause for a motion that I think was to remove counsel, proceed pro se. Kendall White.
Yes, Your Honor.
Pardon?
Yes, Your Honor.
Okay. Is Kendall White here in the courtroom or anywhere that we've seen or had anything to do with it? The show cause order was to shows that on June the 5th, on a motion to set mediation that was filed, neither the respondent nor the attorney of record for the respondent appeared in court, therefore a show cause was issued, and the attorneys and other parties shall appear in the Stewart County Chancery Court on Wednesday, July 1st, before Judge Joshua Turnbow. But Judge Turnbow, that was signed by Judge Lockhart Nash. Judge Turnbow has withdrawn from the case based on a conflict. Court on the June 5th order indicated that counsel for the father should either appear in court or as counsel or file a necessary motion to withdraw as counsel. Have you not heard anything from Ms. White?
No.
Mr. Gang, what is your situation? You have filed a motion to proceed pro se, is that correct?
The most revealing part of her story wasn't what she said. It was how difficult it was to say it. She admitted filming the interview twice because the first recording was unusable. Fear took over. She was too nervous to speak freely. Months later, after seeing more evidence emerge, she returned and finally shared everything.
Pull up towards you.
At this time, Judge, yes.
Have you had any communication with Ms. White as to why?
I believe the last communication I had with him was,
Is this?
I think, after I received the initial order to appear. That's the last time I heard from him. His response was okay. So I have all of that recorded, but there's no response from him whatsoever.
All right, so obviously there's a problem between you and Mr. White, but what I'm trying to figure out is where is Mr. White and why is he not here pursuant to Judge Lockhart Nash's order?
That's a great question, Judge. It's indicative of how he's treated in my case.
You have filed a motion to ask that you be allowed to proceed pro se representing yourself. Do you still wish to do that?
Yes, sir.
You understand that if you proceed pro se, you have every right to represent yourself. If you proceed pro se representing yourself, then the rules of procedure, the rules of evidence, and everything will apply to your case the same as if you were represented by an attorney. The court cannot assist you because that would then be an impartial. It would be showing partiality that the court is required to avoid. You understand what you're assuming to represent yourself, and you want to do that.
At this time, I do, Judge.
All right, then I'm going to order that Mr. White will be removed as the attorney of record. I will further set the show cause back in front of Judge Lockhart Nash as to why he has failed to comply with her order. I want to have an order issued that he must appear before her to explain why he has not complied with her order for show cause. Judge Lockhart Nash is the one who ordered him to appear. I don't know anything about why she particularly ordered him to appear, but clearly she has her reasons, and she may very well incarcerate him on reporting to the Board of Professional Responsibility. So, all right. So we'll send it back in front of her. When is that next day for her? Okay. Second day of October, and this order, when it goes down today, will need to.
While Justin remained calm and professional behind the scenes, private messages painted a completely different picture. Blake and Ryan allegedly mocked him with insults, while publicly promoting a very different narrative. At the same time, the editor hired to create the female perspective says her work was quietly pushed aside.
Mr. White having having had a show cause issued by Judge Lockett Nash to appear, failed to appear, that the court, not being familiar with the reason why she issues a show cause, and supported that he appear before Judge Lockett Nash for answer to her as to why he was failed to comply with the order. Now, then there's a motion to set mediation. Is that correct, Ms. Hudson?
Yes, and when we were here previously in June, we had been ordered to set mediation, have a date certain prior to the show cause that was then rescheduled. At this point, because I could not communicate with Mr. Gang directly because he still had counsel and counsel was not responsive, mediation.
Well, excuse me for interrupting you. After today, we'll fix that problem. Mr. Gang, you are going to be able to communicate with Ms. Hudson, the wife's attorney, directly. Clearly, that means that, counsel in between parties will have a certain decorum that they engage in, and there's not going to be any hostility between the lawyers as usually. So if you communicate with Ms. Hudson, it needs to be done professionally and needs to be done respectfully, whether you agree with what she says or not. It's not a place for you to argue, but you can communicate with her and do so in a manner that would be allowing you to proceed with the case. If you can resolve this case by an agreement, that's fine. If you can't, it needs to be set for a hearing so that you all can present your side and let a judge make that decision. Ms. Hudson, do you believe that, and actually believe that mediation is going to be productive in this case?
That's, I'm not entirely sure that mediation will be productive at this point, and would honestly think it might be better to go ahead and set a final hearing to move forward with.
All right, Mr. Gang, let me ask you this question. You're representing yourself now, and you have every right to do that. Do you honestly believe that going to mediation is where you can sit down with a third party, a mediator who has no interest in your case, and then both sides present their facts and their reasons of what they're asking, and the mediator goes back and forth. The way I used to describe it is kind of like when the president used to bring the Israelis and the Arabs into Camp David and try to get them to agree on some sort of a peace accord. What a mediator does is to try to get both sides to agree on something. I'm asking you as to whether or not, I know Judge Lockett Nash has ordered them to go to mediation, I think, but do you believe that mediation is going to be productive? Do you
Absolutely
think
not.
Okay.
Not with the hostilities that I've received. So the term hostility is very thin.
All right, Ms. Hudson, it's an exercise in futility for me to order that you all go to mediation, spend the money and the time and the effort and attorney's fees plus the mediator's fees to go through a process that is very apparent not going to be productive and not going to be able to be resolved. So I'm going to enter an order waiving the mediation. Now, what is left to get your case ready for a trial?
I'm not sure that there's much left. Discovery has been done. We've had Judge Wallace actually had.
Perhaps the most shocking revelation is that other crew members wanted to speak out but stayed silent. They feared losing their careers, being blacklisted, or facing the power of Hollywood's biggest names. One editor stood almost completely alone, choosing truth over silence.
a hearing and entered a temporary parenting plan. He heard about 2 hours of testimony from the party's oldest daughter. He did go through and already kind of make a preliminary best interest factor determination. And so I think we're pretty ripe for a final hearing at this point.
So if we were going to set it back in front of Judge Wallace, you may have an issue with me waiving the mediation because I think Judge Wallace does require mediation. The other option is that I can set it in front of me, or I can set it with Judge Lockett now to waive mediation. Either one of the orders.
And I don't know that I have a preference on the judge, as long as none of you all are going to be mad at any of the other.
As long as the judges are not going to be mad at what?
At each other. If Judge Wallace wanted to hear it and you've said it in front of yourself,
You're worried about judges getting mad at one another? And so that I'm understanding, you're saying that a judge in our district would get upset that someone took a case off of his docket and put it on their docket, and thereby relieve him from having to hear a contested divorce involving child custody. That's an interesting prospect. Ms. Coffinberry, what do you think about that? Do you think one of the judges is going to get mad if we take a case off of their docket?
Probably not, but we'll see. I think everyone's willing to hear what they need to hear. So
I don't have any desire to hear this case, but I think it's apparent that we can either set it in front of Judge Wallace, who has heard it, which is the most logical thing. But I would need to clear with him that it's okay that I'm waiving the mediation, because it is apparent that that's going to be a waste of time and effort and money. So
yeah, Judge, at this stage, I agree with Mr. Gang's assessment that the back and forth between these, I don't know that they can get to an agreement together.
hold on just a second. I'm going to consult with the boss of this court.
Judge, I've got some questions.
Sure.
So I don't think I'm prepared, as the other parties said that they were prepared. I don't think I have everything that I need because I've kept our position.
What do you think you need, Mr.
I have no clue what my daughter testified to. Zero information on that regarding any of the testimony. I
Well,
have no clue what to prepare myself for or defend myself from. I feel like that is my civil right to understand what to defend myself from.
understand this. There is an order down that allows you to have contact with your daughter, but
Which is not, I haven't had a single
when I'm
information.
talking, if you'll just wait and let me finish before we respond. The thing is, when you're dealing with minor children, the court has put orders down that are designed to protect the children and try to insulate them from being involved in this dispute between their parents. I understand that you want to know what your daughter is going to say. You can consult with the guardian ad litem, who is the attorney that has been appointed to represent the interest of the minor children. You can talk with Ms. Coffinberry. She can talk with the child, and she has, I'm sure, been talking with the child. But under those circumstances, it appears to me that that would be the only way that I would allow you to try to get that information. You're not going to be allowed to take a deposition of your daughter. You're not going to be allowed to sit down with her and cross-examine her during your residential time if you have it. Instead, it's going to have to be done in such a way that it insulates her from being drawn into this as a witness, other than the fact that if she is called as a witness, you have a right to know what she's going to say, if that is possible to be done. So what I'm telling you is that the best way you can act right now would be to consult with Ms. Coffinberry, who is, I'm sure, talking with your children and consulting with them regarding their preferences, and that's the way that you would find that out. As far as being able to speak directly to your daughter about what she's going to say, I think there's already an order down that prohibits you all from talking to the children about the case. And as a result of that, it would be a violation of that order if that was to happen. Now, if I'm advised that if I set this back in front of, for trial in front of Judge Wallace, he's likely to require the mediation that we just found is going to be counterproductive. I've also determined that it's difficult for me to set a contested hearing in front of another judge, such as Judge Lockhart Nash. Ms. Hudson, if we try this case, how long do you think it's going to take to try it?
I would anticipate at least all day, if not maybe more than one day.
All right.
I think that's my one thought with mediation, that there's the potential that maybe the personal property and things of that sort could potentially be resolved, but I don't know. I will defer to Ms. Coffinberry as well.
According to Jacqueline, somewhere there is a director's cut that tells a completely different story. A version that preserves the emotional truth she originally created. Whether the public ever sees it remains uncertain. But if it is ever released, it could completely change how this entire controversy is remembered.
Well, she's the guardian ad litem for the child or children that are involved in this case. So Ms. Coffinberry, do you have any thoughts?
I don't know if the parties really have a lot of, I'm not really involved in the property issues, but it seems to me that would be something that they could resolve by some type of agreement. I don't know that there's a big dispute about property. The main thing is custody and visitation and things like that. That's the rub for these guys is trying to figure out how that's going to look going forward. And as far as their property, I don't know. They can speak to whether they think they could agree on property issues.
Check your calendars. Tell me whether or not you have anything on November the 30th.
All right, hang on. Let's see. November 30th, Your Honor.
Yeah, does he actually have something?
Let's see, what is that? Yeah, no, I'm clear that day.
I am.
And the following day.
I am as well.
You're clear for 30th and the following day?
Yes, Your Honor.
Yes, Your Honor.
The following day is the 1st of December, and that's my circuit civil docket call, and that would be a day that we could go over this case if it didn't have. I'm going to need to step off because Judge Turnbow is scheduled to be here in November, or at least they're showing.
It's his VOP day. That's his VOP day.
That's his VOP. Yes.
Let me go back.
Why has he got a VOP day on the 30th day?
He never changed it. It's kept the way that judges used to have when we were here for a month.
All right. What about the 2nd of December?
I'm available that day.
You are?
Yes, Your Honor.
At the moment, Your Honor, that whole week is good for me. So whatever day.
All right, we're gonna do this. We're gonna start this case at 10:30 on the first day of December, and the second day of December will be the carryover.
Okay.
Now, Mr. Gang, you need to familiarize yourself with the rules of civil procedure that are going to be adhering to your case or applying to your case. One of the ways you can find out what the evidence is to send questions called interrogatories. When you look at the rules, you'll see that under the rules of discovery that you can do that. Send a set of questions to the opposing attorney, asking them what their evidence is going to be at trial and what they expect the testimony to be of those witnesses. You can set that out, and they can answer that question for you, so that you can determine what it is that you need to prepare to rebut, or what you need to prepare to do. You understand that?
I think my question was more along the lines of the testimony that's already been said. I have no clue what that testimony is.
Well, the testimony that's already been brought.
My daughter testified.
Okay, that was in front of Judge Larry Wallace, correct? All
I
right.
have no clue what that was.
All right.
I have
Well,
never been told anything of that testimony.
The only thing I can tell you that it was in chambers, and that was something that was agreed to by your lawyer at the time, as well as the other lawyer, so that the child could testify to the judge, and the judge made certain findings based on that testimony. As far as what she says and what you think, how you're going to find that out, you're going to have to either go to your lawyer to find out what was said. But typically when it's testified in chambers, it's done for the protection of the child and done in order that the parents not necessarily know what the child has said to therefore, wreak some sort of revenge against the child. But it's going to be, I'm not the judge who heard that case. And if I'm hearing your case in December, what I'm telling you is it won't matter particularly what she said to Judge Wallace. It'll be whatever happens in this particular case. Now, with that, if she testifies and you're pro se, she can't testify in chambers. She would have to testify in open court. If that is,
I'm fine with everybody testifying at open court for this now. I think it needs to be brought to light.
we will deal with that at that particular point. But the guardian ad litem represents your children's best interest, and they will deal with that as well. All right, so what I want you to understand is we're going to set this case for hearing on December the 1st and 2nd. Everybody needs to get all the preparation done. There's a motion for contempt. I'm just going to reserve that, but everybody needs, that'll be heard on that same day. There's a motion for civil contempt that's been filed against you for violation of a court order. You need to be prepared to deal with that. It may have been filed while you had counsel, and you're now representing yourself, so you need to address that. Civil contempt is a matter where you are found, if you're found in civil contempt, like the non-payment of monies, then you can be incarcerated in jail until you purge yourself of contempt by complying with the court order. Criminal contempt is where you violate a court order willingly and they prove beyond a reasonable doubt that you have violated the court order. Then you can be incarcerated for 10 days for every violation. That's the criminal sanction. Those are two distinct and different ways. So in civil contempt, it's often said that a defendant who is found in civil contempt holds the keys to the jail. They have the means of getting out of jail by complying with the court order. But Ms. Hudson, since he is now representing himself, I don't think it's appropriate to have the motion for contempt heard, but we'll reserve that for the final hearing.
I agree.
All right. Is there anything else?
And
Judge, I just wanted to ask if on the second day, are we going to start at 9 o'clock if we have it?
On the second day, what?
Day 2 that we've got for the overflow of the trial, is that going to be at 9, or are we going to come at 10:30 on that day too?
10:30 on the first is only on the second, rather. Let me look at my calendar. All right. The first is the circuit civil docket call at 9 o'clock, and I don't know if they'll have anything set or not. If we find out that there's nothing set, then we can start earlier than 10:30, but we usually leave 9 o'clock to 10:30 for circuit civil matters, and then we start chancery at 10:30. So, but on the second day, on December the 2nd, we'll start at 9 o'clock.
Okay. I want everybody to know that, just in case it becomes an issue later.
All right. And
thank you.
Since we're going to be here in this courtroom, I would expect everybody needs to be here. I'd rather do it in person rather than by Zoom. So.
yes, Your Honor. And
James, we'll see you on December the 2nd, December the 1st and 2nd. You understand what you've assumed is representing yourself. You still have the right to hire a lawyer if you choose to do so, but I need to get ready to try your case on December the 1st. Okay.
Okay.
All right.
Judge, I did have some questions. I don't know if it'll be heard or not.
Well, what are your questions?
This has been going on for over a year now of a temporary custodial, I guess, position where I get about 16 hours a week for one of my children. I've been asking since day one to be heard in front of a judge. And of my attorneys that I hired, told me that I will not see in front of a judge. They told me that Judge Wallace will not see me. Will not be heard. I have been begging to be heard to get this change. Just to see one of my daughters. I think I have people outside ready and willing to come in and talk. They see this as being something that's probably undue, and it's definitely not the betterment of the children, especially my 11-year-old daughter. She's confused as to why this is happening. Very confused.
All right,
She doesn't know why.
let me explain to you. As I explained, the rules of procedure apply to you now that you're representing yourself the same as anything else. I don't know what the problem was between you and Mr. White or any of your other lawyers that you may have had. But in order for this court to hear anything in your case, there has to be a motion filed with the court and served on the opposing party and given a date for hearing. Right now, there's no motion pending before this court that would have given Ms. Hudson and your wife and the guardian ad litem notice that you were going to show up today and ask to have a hearing on additional visitation with your child. I understand your frustration, but you need to file a motion and ask for it to be heard in order for that to take place. I can't just sua sponte or instantaneously decide, oh, we're going to go ahead and hear it, and because the other side has a right to get their own witnesses lined up and so forth. That's where having an attorney that is competent would be an advantage to you, to be able to file a motion, put notice to the other party, and try to get a hearing as quickly as possible. Now, I am here in the month of August. I'm not back until December, and those are the dates I've given you for the final hearing. Obviously, at a final hearing, the court will consider the actions of the parties and what they've done as far as giving visitation. That's one of the factors in determining who should be the primary residential parent, is to determine what has been the attitude of the parties in encouraging visitation between both parents. I will look at that point in time. If you file a motion with the clerk will notify me that you filed the appropriate motion and that you are wanting to try to have a hearing to increase your visitation. And I will try to set a date for a hearing that will allow you both to be heard. But I can't do it until you file such a motion. You understand that?
Yes, sir. Yes, sir.
All right. Then I'm going to ask Ms. Hudson that you draw the order for this and include in it that this court is assuming the jurisdiction over this case to allow it to be heard in December.
Can I check on one more question?
All right.
I have pending issues with some of the law enforcement in here where I have received threats from them. And I find it to be absolute intimidation by having them both stand in here and stare at me.
Well, your issue having to do with intimidation, which is, I don't see there any intimidation other than we have security in this courtroom at all times. If you have some personal issue about that, that's not anything that this court is going to consider as far as a hearing. So just, if you have an issue, you can contact the sheriff's department. They're in charge of courtroom security, and you can tell them what your issues are, and they can deal with that. As far as this court is concerned, I'm not going to allow any. Are you looking at them or are you looking at me?
I'm looking at the sheriff and Robbie because those are the two that would be intimidating me, staring at me right now.
Well, they're not going to do anything to you in this courtroom. I can guarantee you that, because to do so would be violating this court's procedures, and it would not be something that I would tolerate. So understand, when you come back to me and for that hearing, I'm going to give you an opportunity. I'm going to treat you with respect. I'm going to give you every opportunity within the rules of procedure and evidence to present your case. But I'm not going to allow there to be any disruption of the case by somebody who acts out. I don't think you're going to do that. You appear to me to be, calm, and I'm going to assume that you're going to behave yourself, just like I'll assume that Mrs. Gang will behave herself. But the only remedy I have if somebody does act up is to incarcerate somebody for an instantaneous finding of contempt of court, and I've had to do that. And in my past judicial experience, when somebody gets mad at what I did and they start cussing me out, I have to find them in contempt and put them in jail. So just keep in mind that I'm going to make a ruling based on the evidence and what I think is in the best interest of your child. I'm going to try to encourage a relationship between you and your children. And if you don't like what I do, then there's going to be a court of appeals above me that will review everything I do, and they'll determine whether I made the correct decision or an incorrect decision. And if they find that I made an incorrect decision, they're going to reverse me and send it back with the correct finding or whatever. All right. that concludes everything that I am finding in this case. We're going to go ahead and set it for that December 1st and 2nd. And Ms. Hudson, if you'll draw the order, please.
Yes, Your Honor. Thank you.
Thank you. Thank you, Mr. Gang. You may be dismissed.